Now, this was the second occasion on which Nani Palkhivala saved the citizenry of this country. One more is yet to come, in which I was involved. Now, let me tell you how. What happened was that the emergency, as you know, got lifted. Janata government came in. A 42nd Amendment Act had been passed by Mrs. Gandhi, which took away or impacted basic structure down the line. Ambassador Palkhivala, as he was at this time, he was in the United States, swore that when he demitted office and came back as a citizen, that he would get struck down in a court of law what the Janata government could not pass in order to overturn the 42nd Amendment. And what the Janata government could not overturn in the 42nd Amendment was two extremely pernicious articles. One was the doing away with Kesavananda Bharati, this time not judicially, but legislatively. How was that purported to be done? You had Article 368, 4 and 5 now added by the 42nd Amendment. What did 4 say? 4 said, the moment a constitutional amendment is passed, no court can judicially review the same. So out goes the court. It can't touch a constitutional amendment. And 5 said, there is no limit whatsoever on the constituent power, which means out goes basic structure. So this is what 368, 4 and 5, which remained after the 44th Amendment, was in our constitution. Equally, you had a new Article 31C now. If you remember, the old Article 31C was only Pope Innocent's 2 directive principles. Now 31C said all directive principles, so that the moment there is a law framed in pursuance of any directive principle, out goes your equality right, out go your 7 freedoms under 19, and out go your property rights, which went out anyway by the Janata regime. So Palkhivala promised that he would get these 2 pernicious articles struck down. He comes back to India. And I was just out of law college. I must have been 2 or 3 months in the profession. And Jimmy Dadachandji, the doyen of solicitors of yesteryear, walked in and said that I will give you a brief which you will never forget. It is an unpaid brief. But you will be the only person assisting Nani in this particular case. And then it gave me the background, etc. And we picked up a petition called Minerva Mills. Something like His Holiness Kesavananda Bharati, which was just picked up out of the blue. Nobody had seen this gentleman. Nobody knew what his petition was about. But anyway, 13 judges deliberated and decided on it. Similar thing happened here. Minerva Mills concerned the Sikh Textile Nationalization Act, which was an act passed under the old 31C. So it had nothing to do with the amended 31C. And this was brought to the fore pretty early in the arguments. Nani had to get over this. So he got over it by saying that, look, basic structure has gone, your judicial review power has gone, nothing more affects a judge than for the judge to be told you don't have the power to do X or Y. My brethren will bear me out. Nobody can tell us you don't have this power. So he played up this. He said, you don't have the power now. Oh, we don't have this power. All right. Then we must go into it. So anyway, they went into it. And the genius of this man, I saw day after day. And what put him apart from any other advocate of the day, if I may put it in my own language, is the fact that for every word that an advocate would use, he would invariably use the simplest. If you had a thesaurus which gives you 6 words, he'd choose the simplest. Second, he was extremely clear in what he said. And third, he buttressed what he said with examples, one after the other. Now, I give you an example of how he attacked the new 31C. He says, the first sentence itself is telling, Article 31C has turned the Constitution on its head, full stop. Whereas fundamental rights are enforceable in courts of law, they have been rendered unenforceable. Full stop. And whereas directive principles of state policy are not meant to be enforced in courts of law, they are now enforceable over and above the head of fundamental rights. Just imagine, these three pithy sentences brings out the entire fallacy in Article 31C, better than anything else. I remember at one stage of this mammoth argument again, it lasted for a month. We had a garrulous judge called Untwalia, very fine judge. And he kept asking Palkhivala questions. And then at one point he said, look, you have been giving us harangue upon harangue about fundamental rights. What about socialism? And then he went into a harangue of his own on socialism. So Palkhivala, who was nervous like this, and he kept on, beating his cheek like this, until finally he says, has your lordship quite finished? He was a very polite man. Yes, I finished. So he said, not even a lunatic, he yelled this word. Everybody got up with a start. Would ever jump the wall from West Berlin to East Berlin. Now, this was the kind of advocate this man was. He could demolish and destroy something that was built up over, let us say, days in one sentence. And he gave examples which destroyed things like this, utterly destroyed things like this. Now, I must tell you that Minerva Mills was a judgment where 4 out of 5 judges struck down the new Article 31C. All 5 judges, including Justice Bhagwati, who was in minority with 31C, struck down 368, 4 and 5. So this was the second time Nani Palkhivala saved basic structure. And it is thanks to this doctrine that every constitutional amendment that, in Dieter Conrad's words, was extreme in nature,